Judges of the court, hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Congregation Yetiv Lev de Satmar against Kehilah. Congregation Yetiv Lev de Satmar of Curious Joel against Congregation Yetiv Lev de Satmar Incorporated. Mr. Novak.
Good afternoon, Your Honor.
Good afternoon.
I'd like to start out by making clear what the real issue is in this case. There's been a lot of pages of briefs. And to do that, let me just go through the chronology. In the trial court, there were two separate elections that were being challenged. There was a challenge to the election of the respondents, and there was a challenge to the election of the appellants, which are my clients. Justice Barish ruled that he dismissed the challenge of both sides.
Well, I thought your position was that their challenge to your election was untimely, and their position was they didn't have to challenge it. It was a nullity.
Yes, that's an additional ground, but he also dismissed it, and they never appealed. So the challenge to the appellant's election stopped at the trial level. In the appellate division, there was one election before the court as to which the issue arose as to validity. That is the respondent's election. In this court, there's one election that is before you. That is the respondent's election.
So does that mean that if you prevail in challenging the respondent's election, your people are in?
Yes.
Does that mean, and your defense was that the time had run, that the challenge was time barred?
Number one, it was time barred. Number two, they didn't serve all of the parties. Number three, they didn't take advantage of the exclusive remedy under 618.
I guess what I'm getting at is this. Suppose Judge Jones, who's not here, and I meet this afternoon and we hold a meeting, we call a board meeting, and we decide we're going to take over the congregation, and nobody challenges it for however many days. Are we in?
I don't think the question is posed properly. The question is whether or not someone has to challenge an election, not a board meeting. There was an election.
So we'll hold an election.
You hold an election. 618 provides that an aggrieved party must challenge it under 618.
So I guess what I'm getting at is that you're saying that immunizes any procedure which the participants call an election, even if the people, even if it's not a colorable election, and even if the people never actually take control of the organization.
I'm saying you can't bring a collateral attack around 618 by saying, I don't think this election was brought on properly. You have 4 months as a shareholder. I'm not talking about outside parties, contract claims. The statute would be meaningless if you had as much time as the respondents are claiming, because they don't want to bother now.
Well, aren't there some, under some circumstances, can't you just treat a purported election as a nullity? You say that's ridiculous, I'm not going to pay any attention to that?
I don't think when you're a shareholder seeking to invoke 618 or a member, you have to bring it within 4 months.
Well, suppose they say, I don't know whether they do say it, but suppose they say, I don't have to invoke 618 because nothing happened. That was a sham election that nobody paid any attention to.
Well, then they're going around and eliminating the statute, because the statute doesn't qualify what the reason is for attacking the election.
So Judge Jones and I could hold an election, and if it's not challenged under 618, we run the congregation.
If the election is not challenged in 4 months, then you have lost your right to challenge it. You can't collaterally attack it. And let me just say that all of this discussion, I think, is irrelevant, because there's been no appeal from the dismissal. So that is out of the case. There's one election before you. That's the election of the respondents. And I'd like to just put that challenge to their election in context. This election took place pursuant to the provisions of the Religious Corporation Law and the bylaws. When the congregation chose to incorporate, no one had a gun to the head. They chose to take advantage of the state statute. As part of that choice, which is entirely voluntarily, they agreed that they would also abide by the rules in the statute, not say, we'll take the benefits, but we don't have to take the burdens. They agreed that they would abide by the secular principles that govern corporate elections and corporate governance. That, in fact, is the heart of the religious corporation law scheme. That is the
There was a
purpose.
law, I mean, having done that, 50 years went by in which the bylaws were observed at best intermittently. Is that fair?
I don't think you can say they've been observed intermittently in all significant respects, Your Honor, and there are issues of fact when they were or were not observed. So I really can't say that the record
Well,
establishes
for
that.
example, when Mr. Friedman became president or was the bylaw strictly observed?
I believe it was. There was an election. You've been told that there was no election. He was appointed. We have record citations for you to show you that there was an election. I'll give it to you in a moment. He was elected in 1986.
The notice provisions were complied with at that time?
Notice provisions for what, Your Honor?
For the election
For
to
the
which
election.
I've referred.
There's nothing in the record on what the notice provisions were in 1986 and how they were observed. But we are talking about whether or not there was an agreement by the corporation here to abide by the secular principles set out in the statute. Their basic position is we don't have to abide by the principles in the statute, nor do we have to abide by the bylaws. We can do whatever we want. We are totally above the law. Our leader is above the law. He's answerable to no one. He can do whatever he wants with the money, and you are powerless to get involved. The members of the corporations or the members of these religious corporations who are intended to be the beneficiaries of the statute, that's the reason they have this governance scheme, are absolutely without any protection by the courts.
By the way, Mr. Novak, were you reserving time for rebuttal?
I'm sorry, Your Honor, I meant to
Okay.
reserve 5 moments. Thank you very much.
Certainly, you're welcome.
If we were to adopt your reasoning, what would the remedy be? Would we have to send this back to
The remedy
Supreme
should,
Court
the remedy should be first,
hearing?
you hold it's justiciable, and I'm going to explain why when you look at the facts that are undisputed, there is no issue of fact as to whether or not the respondent's election was authorized. Then the question is, when you send it back, what is to be done with regard to the respondents? They are holding themselves out as having been elected. If you say they were not, because the election was invalid, to make the relief meaningful, you should also direct that the trial court grant the relief sought in the petition, which was an injunction.
You want us to install your clients as in management of the congregation?
In a manner of speaking, I would like an injunction that directs the respondents to refrain from holding themselves out. Secondly, I would like the respondents to be directed to turn over the checkbooks, the corporate records, the offices to the people who were elected.
Is that all relief we're empowered to give you in this case?
I believe you are, Your Honor. That was sought under 618, you're entitled to enter any order as justice may require in order to make
But
meaningful the
isn't
result.
there a more modest possibility? We could say, we disagree. If we decide it's justiciable, we could say it's justiciable, go justiciate, go decide it.
I think that would be a tragic repetition of the delay that we've had already. I'm prepared to tell you right now what the two pieces of the record are that purport to show that they satisfied the bylaws. Let me just say that the bylaws require, and the statutes require, 3 things: notice, a quorum of a majority, and a resolution be passed. The bylaws require also that any resolutions be passed be put in the minute book. It is undisputed.
And this has been complied with?
It has not been complied with. That's my point. The
And
respondents,
over the years, though, this has been
There's-
very
there-
loosely.
Your Honor, there is a lot of talk, but there's no substantive evidence, and there are no facts that were ever found about what was complied with in the past.
Well, if you got can you refer us to a copy of this minute book?
Yes, it's in the record, Your Honor. I'm going to give
There's
it to the
a
citation.
minute book for this?
Well, the resolution of January 18th, if I just give you the context, Your Honor. There were 3 problems. The question is what happened on January 18th. That is the day, supposedly, that the respondent's election was authorized. In the record, all you have are 2 affidavits with conclusory statements, we resolve to have an election.
The May 24th election you're talking about?
The second election, that's correct, the
Yes,
respondent's
okay.
election. There's the Wertheimer
Authorized it on
affidavit.
January 18th.
Excuse me?
They authorized it on
They
January 18th?
say they did. We say they did not. The Wertheimer affidavit submitted by the respondents, page A188 of the record, it simply says, paragraph 28, at our January 18, 2000 meeting, the board established an election committee. On page 1100 of the record, you have the Schoenfeld affidavit, which says in paragraph 46, As a result of the expulsions, the remaining board members resolved to hold a new official election. That's it. In their brief, they do not contest. They never gave notice. In their brief, they do not contest that they didn't have a quorum, as required by the statute. In their brief, they do not contest that there was no resolution passed. They ignore it.
If you're right about all this, why isn't the remedy a new election?